Which one do you want to do first, Diego or Jose?
Your choice, you're the lawyer.
What? Let's,
Could you look at the docket and tell us what page you're?
I think it's,
Okay, so,
let's see, Diego, judge, is on page 24.
yes, and he's charged,
Jose Severo, male.
Okay, so Jose is on 23.
okay. So I'll read
Huh?
the probable cause.
This on?
I'll read the allegations against your client. It's burglary of an unoccupied structure unarmed, resisting an officer without violence, and possession of burglary tools with intent to use. What is the state's position?
Your Honor, just one moment. I'm sorry, is this Diego Acevedo?
Yes.
This is Jose.
No, this is Diego.
This is Jose.
I just read Diego.
Okay. Well, Judge, the A forms are basically the same on both, but,
All right, so we'll,
My name is Jose.
there you go.
hello, Jose.
Hello.
Okay, so what are we doing?
Well, Judge, I'm not going to make a probable cause argument. There's quite a bit of detail in here. I am going to ask that because Jose in particular is 18 years old with no criminal history, he's actually about to graduate from Western High School within the next week and a half. I'm going to ask just for a reduced bond for $2,500 for each of the felony counts, maybe an ROR on the resisting without based on that lack of history.
And that's on Jose.
That's on Jose.
So on
Yes, ma'am.
count one, bond of $2,500.
That's what I'm asking for, yeah.
Does the state have any objections?
Your Honor, as far as bond, I would ask for $5,000 for count one. Defendant does not have any priors.
So let's do 3,000 on count one. And on count three, burglary, possession of burglary tools.
I'm asking the same $2,500, Judge, which is half of the standard $5,000.
Okay, so I'll do it 3,000. All right, and 100 on the resisting without violence.
Thank you.
Okay, thank you. Hold on.
It's the jail, they need to keep the mind.
All right, so now it's the same thing for your other client, Diego.
I'm right here.
3,100, correct.
And
Of course, there's probable cause. And good morning.
good morning.
Mr.
Now to Diego, please.
Okay, so it's going to be, these are the same charges?
They are, Judge, the exact same charges, same
And
allegations.
3,000 on count one for bond, $100 count two, and 3,000 for count three, and of course, I do find probable cause.
Understood. Thank you very much.
Thank you.
Diego has not been brought up yet, so I just need to probably convey it to him.
Okay. All right,
Thank you so much.
no problem. Mr. Geller, Adam Geller.
How are you?
Good morning, great, how are you?
I'm doing well, Judge.
So, you're representing Mircho Murdeff?
Yes, Judge, I'm here on actually two different people. They're both arrested together. The first one is Mirko Murjeff. That's on page 33, Judge. And I guess we can address them separately. The other one is on page 12. It's Catherine Lichtman.
Yeah. Are you arguing probable cause on any of this?
No, Judge, more of a technical issue. Well, let's address Mr. Murjeff first, since he's up. Mr. Murjeff was arrested on 5/8, Judge. He was charged with 36 counts. It was a warrant that was executed, and there was a Nebbia hold at that time. All of those charges were reviewed in magistrate court by Judge Lee. Judge Lee reduced all of these charges, each and every one of the 36 counts to $5,000 bond, Judge, individually each. And these new charges that we're here on this morning are stemming from allegations out of 2014. These charges should have been included with the original 36. There's 8 new charges, Judge. And originally, the original 36 had a Nebbia hold. That was litigated, that Nebbia was litigated by Judge McCarthy in her courtroom for 4 days, Judge. The Nebbia was satisfied. I do have a copy of the order signed by Judge McCarthy The source of funds in this case would come from the exact same place. I have Mr. Venezia here from the bond company that would provide the same information, Judge. So what we're asking for is just uniformity for these new charges to be addressed the same way that they were by Judge Lee, to have them reduced if possible, and for Your Honor to recognize the order entered by Judge McCarthy satisfying the nebia and the source. And I could provide Your Honor with that this morning.
Granted and granted.
Thank you so much.
So you'll submit the order.
I'll submit the order now. I think they're actually 5. And Judge, and that would be, yes.
For bond,
The bonds will be changed from what they are now to $5,000 each count. That's correct. And then Judge,
Your Honor, that would be over the state's objection as far as the bond amounts that are in the arrest warrant being changed to whatever was done in the order that was done by Judge McCarthy.
yeah, I mean, we'll still do the nebia, but I feel a little uncomfortable doing $5,000 on each.
Judge, and I could provide the court with a copy of everything from the hearing, the original hearing in magistrate court that was heard by Judge Lee. He addressed each and every one of the 36 counts, Judge. The original bond in the first case, the first arrest, was set at just around $900,000. They were reduced to a total of $180,000, which came out to $5,000 per count. And he, presumably, Judge, if these 8 counts were present at that time, would have provided the same uniformity with these 8 counts. There's nothing different. These are included in the grand situation, if you want to call it that. And
So, over the state's objection, I'll grant $5,000 bond on
Thank you,
each
Judge.
of lines.
and the identical argument would be made for on page 12 for Ms. Catherine Lichtman, Adam Geller, on her behalf. I could provide a copy of the order. I could provide a copy of the order just to
Okay.
if Your Honor would like, I can call that back up just to clarify any special conditions, if there are any. And then on page 12, Judge Catherine Lichtman, we'd provide the exact same argument, and it's. North Broward, Your Honor. And you're correct, she's in North Broward.
Good morning, your lawyer is here.
Good morning, Kathy.
Good morning.
Adam Geller on her behalf, Judge. And again, I have a copy signed by Judge McCarthy for the Nebbia situation, and they're the exact same 8 counts added, so. And I'll prepare an order on both of these, Judge, and if there are any special conditions, I'll provide them to the clerk.
And of course, it's over the state's objection.
Yes, Your Honor, thank you.
Does the state have any special conditions they're asking for?
Just whatever the same conditions were on the arrest warrant, Judge. Full, we would ask for the full nebia requirement as well as full collateralization of the.
That's granted, but can you speak so she hears you?
Just, I believe you said it already, Judge, but the full nebia requirement.
Correct, yes.
And the passports have already been surrendered in a previous case, Judge, but I'll include that as a condition in the order.
All right,
Thank you so much.
Thank you.
Yes, thank you.
Okay, Michael Cohen?
Judge Backman, good morning. How are you?
Good, how are you?
Okay, ma'am.
Where is your client?
Dorian Lapointe.
No, but where?
Page 1.
I know.
First on the calendar, Judge. I apologize.
No, I mean, what facility?
Oh, I'm not sure.
Main jail.
Main jail?
Okay.
Thank you. Thanks for the help.
Thank you.
His parents are here, Judge. They're behind me. The father's the alleged victim.
Good morning, welcome.
Just stand right here.
Are you
Thank you.
gonna want them to testify to anything?
Well, Judge, I can proffer to the court the following. I won't contest probable cause, but the allegations in this case are that he struck his father in an argument over a video game with a closed fist. I've spoken to his dad. The dad says it was a pushing match, basically, and a misunderstanding. The fact of the matter is that he's a young man who works at McDonald's, who's gainfully employed. He lives at home. He has no priors. I'm going to as I said, just for purposes of moving this forward, not contest probable cause, but I would ask for the gentleman to be released on his own recognizance. And I think mom and dad want him home, and if the court wants to inquire of the father, who is the alleged victim in the case, he has no concerns at all having his son home.
So,
State
please
your name,
raise
sir,
your
for the
right hand.
record.
Luis Lapointe.
Raise your right hand, please.
You swear and or affirm the testimony you give will be the truth and nothing but the truth.
Yes, Your Honor.
And you still wish your son to come home, even though inappropriately maybe?
For sure, Your Honor.
Okay. Has he apologized to you for showing such disrespect?
Yes, he did.
And who is with you?
This is his wife and his mother.
No, not
Ma'am,
his
could you step up here for a second?
Not his mother.
Oh,
My
you're
wife.
you're his wife, but you live,
Not his mother.
okay, could you, want to swear a judge?
Please raise your right hand. You swear and or affirm testimony you give will be the truth and nothing but the truth.
Yes.
What's your name, ma'am, for the record? You can put your hand down.
Liz Logumbo.
And you're married to the defendant's father?
That is correct.
You live at home?
Yes.
Do you have any concerns at all of allowing him to come home and live with you and his dad?
No concerns at all.
Okay, and do
And
you
you
want
want
him
your
home?
son back?
Yes.
Merci.
And granted ROR.
Thank you, Judge.
Okay,
Thank you
thank
very
you.
much.
Thank you so much.
ROR? Yes.
All right,
Judge,
thank you.
can I
He's
ask
going to
you-
be released on his own recognizance, Dorian, so.
Judge,
we'll
if I
see you at
may,
home.
may I ask you for a no harmful contact order? As far, just in case that condition's violated?
Absolutely.
We have no problem with that.
That's fine.
All right, Judge, thank you very much. Appreciate it.
Okay, now we have Brad Cohn.
Say me, Judge?
Yeah.
Good morning, Your Honor. Brad
morning.
Collins on behalf of Tiffany Schneider. She's related to that other case that was just up, Lickman. You know what? I didn't see what page. I'm sorry. Do you have?
Schneider.
I don't have the page number. It is a felony, yes.
13? Okay, thank you.
Thank you. Good morning.
Good morning.
Your
Tiffany.
lawyer is here.
Okay.
Hi, Tiffany.
Hi, Brad.
Judge, we've had a discussion with Al Goodman from the State Attorney's Office has agreed to a reduction in the bond on this case. It's connected to the Lickman case that was just up, that they already had bond hearings before. This is an arrest warrant that just got served on my client. I think the state will be able to announce what it was. I think that we've
Yes, Your
agreed
Honor,
with-
the agreement,
Go ahead,
I'm sorry. The agreement, Your Honor, was on counts 1, 2, 3, and 4, the bond would be $7,500 each for a total of $30,000. Counts 5, 6, and 7, $5,000 each for a total of $15,000, and the grand total would be $45,000. The other conditions of the bond would remain the same.
So I want to speak to one of those. One of those was a nebula requirement, like on the other case.
Okay,
The
which
bondsman
one?
is present. The person who is securing the down payment for them has already, on those other cases, been satisfied Nebula with the same funds that they're going to be providing on this case. I would like to have that satisfaction be made right now, so that I don't have to go back in front of Judge McCarthy and end up in the 3-day hearing like they were, where we already have everything all secured already. So I don't think there'd be an objection from the state, knowing that it's already been.
As long as the nebula requirement's still in place and it's fully satisfied, the state has no objection.
Okay.
You want to say anything about who provided that for you? The same person on Lickman?
That's her sister. Her sister Melanie is the person who paid for her mother, Catherine, and is also agreed to pay for Tiffany.
All right, so I'm gonna grant your lawyer's request. I do find probable cause, and the bonds stated will remain in place. Okay?
Okay, thank you. Good to
Thank
see
you.
you. Have a happy Memorial Day.
The first 4 were 7,500, and last 3 were a total of 15,000. That's 5 each.
I don't think so. I don't think we did that.
But did we get call out of order already?
I wrote it down.
This one right here.
Okay, now I'm looking for Thomas Motte.
Hi, good morning, Your Honor.
Good morning. Sorry.
See you. Happy Memorial Day weekend.
Thank you, you too.
If I might step outside and have my client's family come inside or call them in, thank you very
Okay.
much.
Do you know where your client is, which facility?
She's a female. Paul Ryan, thank you, thank you. It's a felony.
And this is on Sally Meadow.
Yes, Thomas Mote on her behalf. Her mother is present, so is also her boyfriend is also present, Your Honor.
Good morning.
They're coming in just a
Your
moment.
lawyer is here and some family member? And
Yes.
boyfriend.
There she is. Here's her mother. She's on page 16. Yes, Your Honor, Mrs. McDowell is a lifetime Florida resident. Miss McDowell is a lifetime Florida resident. Her mother is Mrs. McDowell. She has one prior withhold for a felony charge. She has no, to my knowledge, fugitive capias ever issued for her. She's always been compliant whenever she's had an issue. She had recently graduated from the drug court program. She attended it without any issue. So I would proffer to the court, based upon that she's not a risk of flight. I've noticed in the charges, and I just wanted to confirm that with regards to charge number 3, what is the status with regards to the bond on that? Because I'm viewing charge number 3 and it's saying 0 bond amount, Your Honor.
Oh, we have to set a bond.
A bond has to be set on that? Okay, because it's not an offense that's punishable by life.
Correct.
And I believe it, as it's charged, was a first-degree felony, but it is still eligible for bond.
Well, what does the state say?
Your Honor, just double checking the prior, she does have a prior misdemeanor petty theft in 2012. She also has a prior 2011 battery on a law enforcement officer. That was also a withhold. The state would recommend a bond of $25,000.
On counts 1 and 3 then?
Correct.
Okay.
Your Honor, I would ask the court, with regards to that particular charge, I would be making a PC argument with regards to that charge, because if Your Honor, and I have a copy of them in my laptop, which is sitting over there, the actual charge itself that she's charged with of exploitation of an elderly individual has an element of showing that this particular individual is infirm in some particular way. It's not just simply that the alleged victim is 60 years of age. If Your Honor will allow me 1 second, I can read the actual jury instruction to the court, if I might have that opportunity. Thank you very much.
Thank you.
Having some technical difficulties. If Your Honor could pass it for just a moment, and I can address that PC argument with the court. But for whatever reason, my laptop is not allowing me to open that at this moment. If we could pass the matter for a moment, I apologize for the inconvenience to the court.
Okay, then we'll do that. In the state, you have your arguments ready?
I'm sorry?
You have.
I'm looking them up now, Judge. I was
Okay,
just told
all right.
about this argument now.
All right, so we'll go to our regular.
Thank you, Your Honor. I apologize.
Okay, just let me know when you're ready, okay? Omar Gomez Guevara. Good morning, sir.
Good morning, Your Honor.
We need a Spanish interpreter, Kelsey Monahan, on behalf of the Office of the Public Defender.
Okay, she's here. Thank you.
Good morning, Your Honor. Spanish interpreter is present.
Okay, so
Yes, good morning.
swear to translate from Spanish to English, English to Spanish as it is being spoken.
Yes, Your Honor. Luis
And your
Angela
name
Lopez,
for the record,
LLC,
please?
certified Spanish interpreter for the courthouse.
Okay, and who is this with?
¿Y quién es usted?
Su esposa de Omar.
I am Omar's wife.
Okay, so if she wishes to testify, I'll swear her in as well.
Señora, si usted va a testiguar de alguna manera, la señora juez la va a juramentar. ¿Usted va a decir algo?
Solamente que no
Un
quiero.
momento.
Don't talk about the case.
Si
Just
no hable del
tell
caso,
me your
señor.
name
Le está
and that
preguntando
you'll
si
tell the
usted.
truth.
No,
She doesn't want to talk.
no quiere hablar entonces. Si usted no quiere decir nada. No en ese momento.
Solamente quitarlo. No quiero atestiguar en contra ni nada. O sea
I
que,
just don't want to testify against him.
o sea que todo está bien.
Okay,
Everything
thank
is
you.
fine.
Okay, it's nice of you to come.
Está bien
So,
que haya venido, señora.
what is the state recommending? I do find probable cause.
¿Hay un motivo fundado para detenerlo? Fiscalía, ¿cuál es su recomendación?
Your Honor, the state would be asking that if, well, he has no priors, Judge, monetary bond of at least $1,000, and if he's released to either pretrial and no victim contact.
El señor fiscal habla, señora juez, él no tiene antecedentes, querría que le impongan una fianza de $1,000 y si él sale en libertad, que ya sea o lo dejen en libertad bajo los servicios especiales de la corte o que no tenga contacto o comunicación con la víctima.
Okay, repeat again, state what you have it? Okay, I'm gonna go with the first recommendation.
Thank you.
Voy a tomar la primera recomendación.
La fianza la puedo pagar de una vez.
May I pay the bond right away? This person is asking, Your Honor.
You can ask the public defender who's right
Señor,
there.
un momento, le puede preguntar.
Okay,
a-
thank
Your
you.
Honor, he does have another address to live at where this incident did not occur in Hollywood, Florida. We're asking for a pretrial
La señora abogada defensora de la
in lieu of
presente
a monetary bond.
le dice a la señora juez que usted sí tiene otra dirección en Hollywood donde vivir fuera de donde sucedió el incidente, que por favor lo dejen en libertad bajo los servicios especiales en lugar de imponerle una fianza.
So, I can do pretrial release. Can you put the mic down there a little bit? I can hardly hear myself. Thank you. So, pretrial release, I just want to know, ma'am, if you are afraid of him.
Ok, señora. La señora juez quiere dejarlo en libertad bajo los servicios especiales en vez de imponerle la fianza. Lo que quiero saber es, ¿tiene usted temor por su vida con él?
No,
never.
Okay,
Él
so
nunca ha
then
sido
I will grant
agresivo
the
ni
He has never
pretrial-
been aggressive. I'm so sorry. Your Honor.
I will grant the pretrial release, but he has to obey and follow all of the conditions.
Señor, lo dejo en libertad bajo los servicios especiales de la corte, pero usted tiene que seguir y cumplir con todas las órdenes y lo que le digan, señor.
Your Honor, what type of contact?
No harmful
No
contact?
harmful contact?
Pregunta a la señora de los servicios especiales del tribunal que qué tipo de contacto o comunicación puede tener con la víctima. Dice que no se puede comunicar o tener contacto con esta persona, pero sin que cause daño
And no bond required, correct, Your Honor?
Correct.
y
Thank
que
you,
no,
Honor.
no necesita pagar fianza. Correcto.
Okay.
Thank you.
Okay.
All right.
Entonces, ¿cuánto tiempo podría
Timothy
esperar?
Snow,
I'm sorry, Anna. She's just.
¿Cuánto
How
tiempo?
long do I have to wait before it's released? No
Late
sabemos,
this
señora.
afternoon.
Tiene que comunicarse con la casa.
pretrial will answer your
It
question.
would be late this afternoon, but he has to report Monday to our office. He'll be
Bien.
given a map in Spanish regarding our address.
Bien
It's actually
tarde.
Tuesday, Mondays.
Monday,
Monday
you're
the
right.
office is closed.
I apologize. You're
Yes,
absolutely
yes.
right.
Señora, tarde,
Hoy-
quizás esta noche,
hoy
pero
nada más.
a él le van a dar un mapa con la dirección del lugar donde él se tiene que presentar para que lo supervisen
Ok.
el martes en la mañana.
Ok,
Porque el
perfecto.
lunes es festivo.
Ok,
Vaya,
perfecto.
señor.
Thank you.
Okay, Timothy Snow. Where is Timothy Snow? Timothy Snow? Thank you.
Let me get a moment, Your Honor.
Yes.
All right, so, good morning.
Morning.
You're here allegedly on pretrial release condition violation for domestic violence. I do find probable cause, and what is the state recommending?
Just looking to see, I don't have a pretrial warrant. I would ask, he does have a pending first-degree felony in front of Judge Tim Bailey, burglary with an assault. That's case number 18004-952 CF10A. To respond to revoke bond if Your Honor so chooses.
I so choose to revoke bond.
Your Honor, I would just ask, because here's the situation. I talked to Mr. Snow this morning. I see the case that the state's talking about. He was released on that case yesterday. It was a 33-day ROR because the state hadn't brought charges yet. Mr. Snow believed and understood that to mean the case was over. The case is not over. It's just the state did not file charges. And so the victim in that case is the victim that led to the violation, that he basically went back home because it's where he was living before he was arrested. He didn't understand he couldn't go back home, and that's what led to this violation. I would ask Your Honor not to revoke him because from what he's saying that he misunderstood, he does have somewhere else that he can go. He's saying he was not instructed that he had to go anywhere else, that he works as a remodeler, and so his landlord can give him somewhere to stay, basically where he's remodeling. So I would ask Your Honor to give him a monetary bond on this case and not revoke on the other, because he did get out yesterday. He went home. That was the violation because he thought the case was resolved.
I'm sorry.
And Your Honor, it is a first-degree felony. The victims are the same. So I would ask that that's to bring it to the court's attention, I guess.
So if I set bond and I don't revoke the other bond,
That's what I would ask you to do, Your Honor.
okay. So, any suggestions? I know it's a first-degree felony.
This one is not the open case.
This is a misdemeanor pretrial release violation.
Okay, so it's misdemeanor.
Correct.
So what is the standard bond for that normally?
I believe it's 1,000, Judge, but I would be asking for at least 5,000.
Okay, and I'm going to grant $5,000 bond and not revoke the other one. Okay, thank you.
And Your Honor finds PC.
I found PC for sure. Thank you. And no contact, right?
That's what I'd be asking for, Your Honor.
Yeah, if I may call just two from the city of Fort Lauderdale.
I don't know where they are. Okay, so in the meantime, let me.
Okay, I'll wait till you pull up.
No, I'll just take two cases and.
Okay, great. Thanks, Judge.
Thank you. Okay, Khalid Zayden. Where is Khalid Zayden? Good morning, in the main jail. So, sir, you're being charged with allegedly violating an injunction for protection from domestic violence. Any probable cause arguments here? Are you hearing me? Are there any probable cause arguments here?
Diverting to Mr. Dressler, Your Honor. He's making the probable cause arguments. I just make the bond amounts.
Hold on. I thought we were done with him. This is, what is this person's name? I thought we were done with him.
I believe it's Mr. Zayden, Judge.
Well, it is Mr. Zayden, okay.
It is.
So, good morning, and do you have any probable cause arguments?
Your Honor, can we put this on a brief recall?
Just deferring to counsel, Judge.
Robert Rodriguez. Good morning.
Good morning.
So you're being charged with alleged touch or strike, battery, dating, violence. I do find probable cause. What is the state's recommendation?
Your Honor, the recommendation based on the defendant's priors, he has a 2007 possession of cannabis, he has a 2007 false imprisonment with a battery attached to it, and a domestic violence violation. He also has a 2006 aggravated battery of a pregnant female, so I'd be asking for at least a $5,000 bond, Judge, if he's released to go to pretrial, no victim contact.
Well, I'm gonna set bond at $7,500, and the following condition, if he makes bond, pretrial release, no victim contact. Okay?
Thank you, Your Honor.
Thank you. Okay, so these two are the Fort Lauderdale. So next I'm calling Shwanta Donald. This is Fort Lauderdale.
Yes, Your Honor. Ms. Donald is located on page 9.
I've got it.
I had an opportunity to speak with her, and I'm just asking that this case be sent to division. She's at North Broward.
Yes, she was at North Broward, but she was very, very sick. So we had to send her back to the housing unit.
Okay, so it's a medical reset, and what?
Yes.
We'll move it to
Sure,
tomorrow.
that's fine.
Okay, next is Wilmot Brown.
Your Honor, this case is on page 22.
North Broward, Judge.
Good morning. So I do find probable cause on counts 1 and 2. What is the city recommending?
Well, I'm not here for the city, Your Honor. I'm here for the Public Defender's Office representing this case that the city has brought against Mr. Brown. I'm just asking, I do have some mental health concerns, and I'm just asking that this case be sent to division.
Okay.
We're not going to resolve today. Thank you, Judge.
Thank you.
Bye.
Are you going to state which division? Do you know which division?
I don't know what division
Okay.
yet, Your Honor.
Thank you. Mr. Collins? Yeah.
Judge, just a final housekeeping on Tiffany Schneider that you granted the bond reduction in the Nebbia requirement. I have the order done, but in the original warrant, it says the defendant shall surrender her passport. And I don't have possession of it yet, but I wanted to submit in the order that the defendant submit her passport within 48 hours of release. If I can get it sooner, I'll have them send it to my office and I'll turn it into the clerk, but I don't, she has little kids and she lives here and owns property, and I just wanted to put that in the order if that's okay.
That's fine.
Okay.
Is that okay
Yeah,
with
we
you?
called.
I'm sorry to interrupt, but I don't have a passport.
Oh, even better. So I'll put in the order, if she has a passport, she shall surrender it. I'll put that in the order. Is that okay, State?
That's fine.
Okay.
If she has a passport.
I just didn't want that to bar her from being able to get out now, because they read it very literally, and if it was on there and she didn't turn anything in, she doesn't have it. So I'll put that in the order.
All right,
Okay.
thank
All right,
you.
Tiffany, thank you.
Thank you.
Thank you. Okay. Are we ready? Okay, we did Khalid Zayden. We did that? That's on
can't
recall.
hear you.
So is
Yeah.
Sally Middow with the attorney. Are you ready?
Yes,
Passport,
ma'am,
she doesn't
thank
have
you,
one.
I
Passport
apologize, my
surrender if
computer
she
is
gets
frozen
one.
on me.
She doesn't
Okay,
have one.
so
I think she was calling a case, I don't wanna be rude.
I thought I did both your cases.
No, this is a different matter, Your Honor. Right, good morning, Marcy Hall, appearing on behalf of Zachary Williams. For some reason, my client is not appearing on the docket, and I don't know why. It was one. He's not.
Yeah, if you can. Okay, thank you.
Thank you very much, Your Honor, and I apologize, my computer had frozen, but I've got it working for now.
Okay, and where is,
Sally Medall, her family was outside.
right, but
They-
what facility again?
Oh, Paul Ryan, Your Honor. She's on page 16 of your calendar. Thomas Mote again on her behalf.
All right, good morning again. So we were talking about the alleged exploitation elderly.
Yes, Your Honor, and if Your Honor was to review the jury instruction 14.9 as it relates to exploitation of an elderly person or disabled adult, one of the requirements for a probable cause or for the initial elements that the state has to provide evidence as to is not simply an issue of age. It also has to demonstrate that the person is an elderly adult. And they define in the statute, 825.101 sub 4, what constitutes an elderly adult. And it's also defined in that same jury instruction that I quoted for the court. And an elderly adult is defined as means a person 60 years of age or older who is suffering from the infirmities of aging as manifested by advanced age or organic brain damage or other physical, mental, or emotional dysfunctioning to the extent that the ability of the person to provide adequately for the person's own care or protection is impaired. And that is a very important detail that is not in this arrest affidavit whatsoever. There is absolutely no allegation, as I've read through it this morning, that the elderly victim, Mr. Kevin Hurley, qualifies as an elderly adult, elderly person, as required under 825.104 sub 4, because although it does allege his age, which is 67, it does not allege any of the other necessities in order to qualify as an elderly person. Based upon that, Your Honor, we would be making a probable cause argument in reference to the exploitation charge, which is a first-degree felony, and the state is wishing a $25,000 bond on. But we would ask that matter, due to a lack of probable cause for that particular element, that the defendant be ROR'd on that charge for the lack of PC. If the state later on in information is able to allege that some other mechanism, then that can be readdressed by the court. But at this juncture, we would be asking the court, with regards to the exploitation of an elderly person charge, to ROR her. And given her lengthy contacts with the community, her entire life, and lack of any sort of showing of any sort of absence or disobeying of any court order at any time, we would be asking for a total bond for all counts of $10,000, except for count 3, which is the exploitation of an elderly person charge. We would be asking that be ROR.
Okay, thank you. State your response.
Your Honor, according to 825.103, the statute reads exploitation of an elderly person or disabled adult. It sounds as if counsel's making the argument that the finding of disability needs to be made in order to satisfy PC. The state would be arguing that that's not the case. As far as the jury instructions under statute 825.101, defense counsel is correct. Elderly person means a person 60 years of age or older who is suffering from the infirmities of aging as manifested by advanced age or organic brain damage or other physical, mental, or emotional dysfunctioning. It's not and, as counsel would be reading the statute. So it's not a finding that has to be made including some form of disability that goes along with it. The statute reads or, and that's very evident as the heading of the statute says elderly or disabled, as well as the definition that's under statute 825.101. So I'd be arguing that there is PC based on the age of the person. He's 67 years old. And as far as, I don't think there needs to be a finding of a disability or some kind of physical or mental handicap to go along with that in order to find PC.
Your Honor,
Briefly.
if I could rebut, the statute reads elderly person or disabled adult. Okay, this is not a disabled adult, so that issue is quickly, but
With all
the.
due respect, counsel, I hear your argument. I've been looking at the statute, and with the facts of the case, I do find probable cause on 1 and 3. Over your objection, of course. And what is the state's recommendation for bond?
I believe, Judge, based on her priors, the recommendation was, I believe it was 50,000
On each?
for counts 1 and 3, but the rest would be the 1,000 that's stated in the 1,000 for the rest of the counts. But 1 and 3.
1 and 3 are 25,000, and 2 is 100, and the rest, 4 through 8, are 1,000 apiece. Thank you. Hold on.
I have 15 counts as well.
I do too.
So, Your Honor, setting individual bonds of 25,000 on count 1 and another 25,000 on count 3?
Yes.
Would the court reconsider that issue, given the fact that she's not a flight risk? She's complied with everything that's necessary. We're talking about her having to pay approximately a total bond amount that's going to be roughly over $60,000. Would the court consider a $30,000 total bond amount? She voluntarily, I forgot to mention this, Your Honor, she voluntarily surrendered twice. When she contacted me, she was told that there was a warrant that was out for her arrest by Detective Mullen. I immediately got myself in contact with Detective Mullen, and she voluntarily, personally delivered herself to the Coconut Creek Police Department last night. And she had also done the same thing the day before when we had learned about it. She had gone to the Broward Sheriff's Office because we were informed that there was a warrant for her arrest. And then she went over to the Broward Sheriff's Office. We learned that there was no warrant for her arrest. She went back home. She went to work the next day. And then the following day, they put themselves in contact with me, who I was able to get a hold of Detective Mullen, who said no, that this wasn't a warrant for her arrest. This was a probable cause arrest. And I said, well, she's been trying to turn herself in yesterday already. She's willing to surrender. She voluntarily, personally came. No one had to look for her. She came to the Coconut Creek Police Department. She surrendered herself as quickly as can be required of her, even more quickly.
So instead of $25,000 for 1 and 3, you're asking me for $10,000 for 1 and 3?
Yes, Your Honor.
All right, I'll do that.
Okay.
Okay, thank you.
Thank you.
So the total bond would be at this point?
Yeah, they're 1,000 apiece.
Thank you, Your Honor.
Thank you.
Thank you. Have a nice weekend, Your Honor.
Thank you.
Thank you. Okay. Are we ready now on Khalid Zayden?
Bless you.
What happened with Mr. Zayden?
Yes, Your Honor. No probable cause argument.
Okay, and what is your argument?
We are asking for a pretrial release. He's lived here 13 years. His wife and children also live here in Broward.
So where's the probable cause argument?
Oh, no probable cause argument, Your Honor. I just didn't have time to review it before, so I wanted to double check.
Okay, so there is probable cause, and what is the state recommending?
Your Honor, the state would be recommending a bond of at least $1,000. If Your Honor is going to read this into pretrial, I would ask for no victim contact. There is already a restraining order, but I would ask Your Honor to ask for no victim contact.
Okay, $1,000 bond, and if he bonds out, it'll be pretrial, no victim contact. Okay, thank you. All right, moving right along. Simon Cabral. 1 minute. Simon Cabral. Good morning. Sir, I find probable cause for touch or strike battery, domestic violence, and if you could state, what is your recommendation?
Your Honor, the defendant has no priors. I would recommend at least $1,000 bond, and if he's released, that he have no victim contact.
Okay. Then that's
Your
what
Honor,
I-
we're requesting a photo order
you can
for
add to.
this case.
Okay, no problem.
And
So it's
this is
$1,000.
to prevent.
I know.
So we are arguing for just pretrial. This is a brother. It was an incident between a brother and a brother.
All right, so it'll be pretrial release, no victim contact. I hope they don't live in the same home. And a photograph.
Thank you, Your Honor. Can we ask for no harmful contact since they are brothers?
State, do you have an objection to that?
Is there any evidence that they, let's see if they live together, just one moment to live together? Yeah. No harmful contact is fine, just.
Okay, you got it. Thank
Thank
you.
you.
Okay, what are we doing with this young lady who's not on the docket and I don't know what's going on?
Yes, good morning, Your Honor. Marcy Hall for Zachary Williams. And I checked, and the reason that my client's not appearing on the docket is because he was arrested on a warrant from Port St. Lucie County. And the clerk has informed me that because he's not under the jurisdiction of this court, that he has not been brought to court today. And Your Honor, I have done some research under the Florida statute 901.07. My client, based on this statute, is entitled to a bail. He's entitled to actually be released on bail based on the fact that his warrant occurred out of another county and that he was arrested on a misdemeanor domestic battery warrant or domestic battery charge. And based on those facts, my client should be here today and he should be entitled to bail. Zachary Williams.
A little louder, please, there's a lot of noise.
When we get the out of county, if the only charge that he has is an out of county hold, we set whatever bond, St. Lucie County or whatever that county is, if they give him a bond. If the warrant says no bond, we can't change that.
I don't know what the warrant says, because I don't see it.
Right, I don't have it. I mean, I can look it up and see if it's, let me call, I'll call.
Okay, so we'll recall your case.
Thank you, Your Honor.
All right, Brent Fetterman.
He's in North Broward, Your Honor.
Thank you. Good morning. Is Mr. Fetterman here?
Yes, he's refusing to come before you, Your Honor, but he can hear you. Okay, here he comes. Morning, Your Honor.
Good morning.
And Your Honor, just for the record, he refused my services this morning, so he's representing himself.
Correct.
Okay, so, Mr. Fetterman, you're being charged with a capious misdemeanor, and it looks like Judge McHugh is your judge, correct?
Correct. I was arrested yesterday at the racetrack with no probable cause. I have the manager's paperwork that also shows that she never called like Broward Sheriff's Office Department said. I've been involved, I guess, with
Okay,
this
so this is
program
what-
you guys have
Yeah,
that you guys been trying to want me to be a part of. That it's just not working out.
okay, so, don't talk about your case. State, any recommendations?
Your Honor, the warrant says no bond, so.
Okay,
state
the
would
warrant
seek by
says no
letter.
bond, and I can't change that. So,
Can you find probable cause though?
I certainly do, sir, thank you.
On which one? Your Honor, may I say, I have not been served no paperwork, have not seen no medical.
Schuman Robert.
Your Honor, as a friend of the court for Mr. Fetterman, can I just ask Your Honor to get a medical and mental eval for him?
Absolutely.
I'm not representing him, I'm asking it as in front of the
All right,
court.
thank you.
It's been 12 hours for the house.
Thank you. Robert Schuman. Good morning. Sir, you're being charged with battery, cause bodily harm, dating violence. I do find probable cause, Any objections anywhere? Any recommendations?
One moment, Your Honor.
Your Honor, he does suffer from Parkinson's and he has a heart transplant. He's an Army vet. He served in Vietnam. We're requesting pretrial.
Your Honor, I'd be asking for no victim contact if Your Honor was going to ROR to pretrial. He has no priors.
No victim contact, ROR, pretrial, and there is a veterans court too, so hopefully everything will work out with you. All right, thank you.
Thank you, Your Honor.
Agnello Madrio.
She can find some resistance.
Good morning. Good morning, sir. You're being charged with felony battery, domestic violence. I do find probable cause. Any arguments from anybody else?
Your Honor, the defendant does have some priors. He has a burglary of a conveyance and a petty theft from 2009. He also has 5 other counts of a burglary of the conveyance. Based on the nature of the charges, I would be asking for at least a $5,000 bond on. One moment, Judge, sorry. And Your Honor, the defendant and the victim also have kids together, so the state would be asking for a third party to handle the contact between the defendant and the victim, as far as the child care goes.
Your Honor, they don't live together. He lives separate and apart from the victim. He's lived in Broward his whole life, and he does have one son here. We're asking for pretrial and no harmful contact.
And what was the state's recommendation?
I recommended $5,000, Judge. It was a felony battery.
So it's going to be, I'll be Solomon, $2,500 bond, and if he bonds out, pretrial release, no harmful contact. No harmful Did you say no contact?
I asked Judge, they have children in common, so I would ask for a third party to handle the contact between the
That's
defendant
what
and the
we'll
victim
do.
regarding child care.
Regarding childcare, so that's fine. And with each other, no contact.
Thank you, Your Honor.
Thank you. All righty.
My handwriting's terrible, I apologize.
Grayo Houston. Huston. Good morning, sir. You're being charged with 1 count of aggravated stalking after an injunction for protection of a domestic. A second, criminal mischief, $200, under $1,000, violation of protective order, and resisting with violence. I do find probable cause. What is the state's recommendation?
Your Honor, the only case that I'm showing is the pending domestic violence battery that it looks like that was the injunction that he violated. Due to the nature and circumstances of this case, I'd be asking for a $10,000 bond for count 1. If he is released, if he does make that bond, to go to pretrial and no contact with the victim.
Okay.
Your Honor, I do have a PC argument. The PC does not allege that my client was served with this injunction. Therefore, there's no knowledge that he would be willfully violating it because he was never served with it.
Okay, that's interesting, but I still find PC. And what about the count 3 and 4? We have to set a bond. What is the state recommending?
I'd be recommending $1,000 for count 3, $5,000 for count 4, Judge.
Okay, so done.
Your Honor, requesting a photo order.
And a photo order.
Thank you, Your Honor.
Count 1 is 10,000, count 2 is 100, count 3 is 1,000, and count 4 is 5,000. Thank you. Tarsi Birch. Good morning. Sir, you're being charged with domestic battery by strangulation and touch or strike battery domestic violence. I do find probable cause. What is the state's recommendation?
Recommendation, Judge, one moment, just reading the warrant. The defendant does have a domestic violence prior that was dropped. Other than that, he's showing no priors, or I'm showing no priors. I'd be asking for a $5,000 bond on count one, $1,000 bond on count two, and if he's released, no victim contact, or if he makes bond, no victim contact.
Okay, so on bond on count one is $6,000. On count two, what did you say?
At least 1,000, Judge.
Okay, so $2,000, and if you are released, no victim contact. It's a pre-trial release. If he makes bond.
Your Honor, defense is requesting, he's lived in Broward his whole life. He works in labor. He has two children that that live here. His dad lives here. He shares custody of these children. He can afford about $300 in bond total, but he can't afford $7,000.
And I turned myself involuntarily last time.
And he turned himself voluntarily last time.
What?
The victim's name is Vivian Mastrapa. 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 Yes, ma'am.
And Judge, based on the facts in the PC and that it's a strangulation, I think $6,000 is completely appropriate.
And I'm keeping bond as it is. Thank you.
I'll go with her, madam.
Okay. Robert Rifkin. Good morning, sir. You're being charged with one count of You're being charged with one count of aggravated assault with a deadly weapon, domestic violence, aggravated assault with a deadly weapon with intent to kill, and count 3, grand theft firearm. Any probable cause arguments? Because I do find probable cause. And what is the state's recommendation?
No probable cause argument, Your Honor.
The recommendation, Judge, the defendant does have some priors. He has a burglary of a dwelling and a grand theft from 2013. He has 3 separate charges of possession of cannabis. Based on the nature and the circumstance of this case, Judge, I'll be asking for at least a $10,000 bond on both counts 1 and 2.
Okay, well,
And no victim contact if he's released.
I'm going to order count 1, $15,000 bond, count 2, $15,000, and count 3 to $1,000. No victim contact. Thank you.
And Your Honor, requesting a mental health eval.
And a mental health eval.
Thank you.
Imre Sidai. ZSIDAI. Imre. Hey, throw me a bone here. Good morning. Sir, you're being charged with alleged domestic battery by strangulation, 2 counts of battery on an officer, 3 counts of aggravated assault on an officer, 1 count of touch or strike battery domestic violence, count 8, another resisting an officer, and 9, the same thing. I do find probable cause. What is the state recommending?
Your Honor, he's showing no priors as far as count one, due to the fact that it is strangulation. I'd be asking for at least a $6,000 bond. For count 2, at least a $5,000 bond, as well as counts 3. For the aggravated assault, I'd be asking for at least a $10,000 bond for counts 4 and 5 and 6, and $1,000 for count 7. And I believe.
And there's 2 resisting with
I'd be asking for $5,000 on count 8 and $1,000 on count 9. I'm sorry, there's already bought, so $100 for count 9, excuse me.
Yeah, there is, okay. So I do find probable cause, and bond is set as follows. Domestic battery by strangulation, 7,500. Domestic battery by strangulation, bond is set at 7,500. Battery on officer, twice, $5,000 each. Aggravated assault, there's 3 cases, 3 charges of that, and that's $15,000 apiece. Touch or strike, domestic violence, what did you recommend?
At least $1,000, sir.
Okay, so that'll be $2,000, and for resisting the officer with violence, that's going to be $7,500. And on the last one, bond is $100, and I do find probable cause on all of
And no victim contact, Judge?
them. No victim contact.
Your Honor, requesting a photo order and a mental health eval.
Okay, you got it.
Thank you.
Curtis Elliott.
Comfy?
Yes, ma'am.
Good morning.
No, neither.
Sir, you're being charged with alleged domestic battery by strangulation. I do find probable cause.
Your Honor, this is actually set for a 72-hour reset because originally the judge did not find probable cause on this. I have not received anything from the state to show they've perfected in the 72 hours. I don't know if Your Honor has.
Well, somebody wrote no bond on count 2. And $10,000 for count 1. That was a Jeff Cohn finding, and that's dated. So state, what are we doing here?
Just one moment, Your Honor. I don't have any paperwork on that yet. I'm reaching out to the prosecutor now, and we're printing out the paperwork now to review.
Just the officer briefly observed the video from CSL Plasma and should be noted that D/M was observed placing the female in a choke hold from the rear and walking her into the vehicle. And he has an outstanding warrant out of North Carolina. And the victim, LaShawn Kurla, does not remember being thrown to the ground and stated she doesn't know if she passed out or not. So with all that being said, I find probable cause and bond is set at $20,000 and no bond on the out-of-state hold. Okay, so $20,000 probable cause. Thank you.
Judge, I would ask at the minimum that you would leave it the same. The state has not produced anything new, and the original judge did not find probable cause. So not only are you overruling a judge, you're also changing that judge's bond that they set without any paperwork from the state, even though another judge required the state to produce more paperwork to find probable cause originally.
Okay, so you make a good point, $10,000 bond. And I do find probable cause. Thank you. And no victim contact. Adrian Williams. Adrian Williams. Thank you. Record, I find probable cause. Eric Owanga.
What did he bond out? There's no. Well, no. I'm not showing that there was a bond set. It says hold for magistrates. My paperwork is showing.
Yeah, that's what my note is. He went before his division judge.
Ah, okay. Sorry about that. Okay.
So you're Mr. Awanga, yes? Good morning.
Good morning, Your Honor.
Sir, there is an out-of-state felony on you, so no bond. Thank you. There is probable cause. Jenny Perdomo. Is Jenny Perdomo? Is Jenny Perdomo there?
Yes.
Where is yes? Maine?
Oh, main jail.
Thank you. Good morning. You're here, ma'am, on a capious misdemeanor. Trespassing on private property, allegedly. I do find probable cause, and bond is set at $100.
Okay,
Where's, yeah?
yes, let's passing a warning on a private property,
Okay, don't argue your case in front.
Okay.
You could be, hurting your case. So bond
Okay.
set at $100, okay? And there is probable cause. Thank you.
And I would say it is a municipal ordinance, so she is representing herself.
No, I understand.
Just smart.
Can you afford $10?
I can't afford, but if I could make payments plans, it's options payments, then it could be, reasonable, with it.
Okay, you know what, I'm gonna release you ROR and just make sure that because there's probable cause, you show up to the judge in question.
Okay.
Thank you. Christine Pitts.
No problem, Your Honor.
Good morning. Ma'am, you're here on an alleged capious misdemeanor. I do find probable cause, and it looks like bond was set already at $1,000.
And Your Honor, I spoke to Ms. Pitts this morning. She is interested in resolving the case this morning, if Your Honor is so inclined to a time served. I looked at the probable cause affidavit. I forget if it was some sort of store. I think it was a CVS. I could pull it back up. But all the items were retrieved at the time, so there would be no need for restitution. I believe the total amount of the items was about $57, if I'm remembering correctly. So I'm asking for Ms. Pitts if you're willing to resolve today.
Yes, I am.
Your Honor, she has a previous trespass in a structure that was a withhold misdemeanor 2016. And that's all the priors that I'm showing that are in state.
Okay, well, so on this one, we'll resolve it with an adjudication. You'll get fingerprinted, time served, and any applicable court costs. Okay? Good luck to you. Thank you.
Thank you.
Jenny Perdomo, that was you, right? Okay. Brianna Capizzuto.
She bonded, Your Honor.
Thank
She
you.
bonded out.
Thank you. Melanie Miner.
She's a medical reset.
Okay, thank you.
You're welcome.
Brittany Chisholm.
Medical reset as well.
Tamara Spence. Thank you.
Paul Ryan, Your Honor.
Thank you. Good morning.
Good morning.
Are there any probable cause arguments on Ms. Spence?
No problem.
Robbery,
No probable cause argument, Your Honor.
robbery, firearm or weapon, and grand theft less than $5,000. I do find probable cause. And what is the state recommending?
Your Honor, the priors, I have unlawful use of ID that was in 2018, grand theft adjudication in 2017, as well as a petty theft, prostitution charge in 2017, DWS in 2015, unlawful use of ID in 2015, as well as a grand theft. The only thing that I'm showing in my packet is the grand theft charge. I don't know if bond was previously set on count 1. I'm showing a bond amount for count 2. Recommendation would be $1,000.
And for count 1, 2,500?
Yes, Your Honor.
Okay, so done. Thank you. Tana Renee Comer.
Angel.
Good morning.
Good morning.
Okay, any probable cause arguments? Because I find probable cause
No, Your Honor.
on aggravated battery causing bodily harm, a second aggravated assault with a deadly weapon without intent to kill, and a no bond for burglary with assault or battery, and criminal mischief over $1,000, bond $500, operating without a valid license, $25. So what are the recommendations for 1, 2, and 3?
The recommendation for count 1, judge aggravated battery causing bodily harm or disability, be recommending a bond of at least $15,000. The defendant does have traffic criminal priors and a 2002 forgery. Count 2 would be asking for at least $10,000. Burglary with assault or battery. State would be asking you to find proof evident presumption great for that. Excuse me. Yes, for burglary with assault or battery.
Okay. So for count 1, aggravated battery, 15,000. Count 2, 10,000. Count 3, this court does find probable cause in your case, and I further find proof of guilt to be evident or the presumption great. Therefore, you are to be held without bond until further order of this court. And this order is without prejudice for the defendant to file a motion to set bond with the assigned division judge under and request a hearing under State versus Arthur. Thank you.
Your Honor, I'm objecting to the finding of proof and or presumption great under count 3. I'm going to cite to Yasaza v. State 222 Southern 3rd 3. The state has two options if it wants an individual to be held pretrial without bond. They could file a motion, which they have not done, so they're asking Your Honor to find proof and or presumption great. Having reviewed the probable cause affidavit, there's no mention that any of the statements taken from any of the witnesses or alleged victims were actually sworn to. The fourth DCA, which rules over this court, is clear that proof and or presumption great actually goes beyond a reasonable doubt. And I do not believe that the state would even be able to meet their burden of beyond a reasonable doubt today just based on this probable cause affidavit. We have no sworn testimony, we have no live testimony, we have no sworn affidavits. And so, Your Honor, I would object to finding a proof and presumption great to count 3. Even if Your Honor does make that finding, Your Honor could, within your discretion, to set a monetary bond.
Okay, thank you. I'm going to keep things the way they are over your objection.
And Your Honor, requesting a photo order, please.
And a photo order.
Thank you.
All right. Now we have Reshma Madre. Reshma. Good morning.
Good morning, Your Honor. How are you?
I'm good. I hope you're good too, but you're being charged with 4 counts of allegedly neglecting a child without great bodily harm. Any probable cause arguments? Okay. What is the state recommending?
The state would be recommending, for count 3, at least $10,000 bond. I'm showing the defendant does have no priors. Counts 1 through 3 would be asking for $10,000 bond, as well as count 4.
And Your Honor, this is her first offense. She's lived here 4 years. She has 4 minor children. Her children go to school here. She shares custody 50-50. She works at Dunkin' Donuts. At the most, she can afford a $200 bond. And if the court is not so inclined to set that low of a bond, requesting pretrial and a DCF evaluation to get this in order to make sure, you know,
Okay.
figure out exactly what's going on.
It's a misunderstanding.
So, yes, I'm going to order pretrial release with the DCF investigation, and bond in total is $5,000.
Is that each count, Judge, or how do you want it?
Let's do,
I have to.
yeah, each count 5,000. Thank you. Hannah Holt. Hannah Holt.
No problem, Your Honor.
Thank you.
No.
Good morning.
Good morning.
Ma'am, you're being held today on one count of a violation of felony probation, a capious felony, a warrant retrial felony, and a capious felony, for which no bond is.
Yes.
So there's no bond, and you will be in front of your judge on June 1st at 8:45 a.m. And I do find probable cause. Thank you. Yes.
Can I correct the case number for count 4?
Correct the case number, yes?
17.
Yeah. TF 10A. Okay, thank you. No, I didn't sign this. Sharni Avril?
Bonded.
Thank you. Probable cause was found.
Manger.
The bond was posted.
Your bond has been posted, okay?
Oh, okay.
Thank you. Stephanie Cavallo. Stephanie Cavallo?
No problem, Your Honor.
Okay, good morning. Ma'am,
Morning.
you're being charged with alleged possession of heroin, a second possession of cocaine, drug paraphernalia, and violating community control for on a felony for which there is a no bond hold. I do find probable cause. Bond on count 1 is $1,000, count 2, $1,000, paraphernalia, $100, and the probation violation, no bond. Thank you.
And I have a case number for number 4.
You have a what?
Case number for number count.
Can you tell me my court date?
It's 18.
1 second, louder, please. We're talking about Stephanie Cavallo, probable violating community control on a felony.
Yes.
Okay, and what case is that?
Case number is 18.
Uh-huh.
674 CF 10A.
674 CF 10A.
Ma'am,
Don't
when will
talk.
my court date be?
I don't see anything showing right now, but hopefully soon. Okay?
Thanks.
Nope. Okay. Jennifer Stevens. Good morning.
Good morning.
Ma'am, you're being charged with alleged burglary of an occupied conveyance unarmed, for which there was a no bond hold, and petty theft. We need to set bond, and that is $1,500, and I do find probable cause. Okay, so my bad. What do you suggest, State?
I would suggest at least $15,000, Judge, for the bird dwelling charge.
Your Honor, when it comes to the speed of her still for her this morning, she lives in South Florida for over 2 years. She works as a landscaper. She also works painting. She makes about $500 a week. I'm only able to speak to her because this is a mixture of traffic infraction and miscellaneous misdemeanors. I don't see any prior felonies for her in her hours. Based on that, Your Honor, and also the routine probable cause affidavit, I would ask, Your Honor, if you would consider some sort of non-monetary release, even with an electronic monitor, because from my understanding, what Mrs. Stevens told me, she's unable to afford any monetary monitor.
Well, if you do pretrial release, I'm going to order that you have an ankle monitor and
That's fine, ma'am.
that you take some, all right. All right. So that's what it is.
So
Good luck to you.
that means I go home today with the ankle monitor.
Yes,
Okay.
they just need to verify your address.
Okay.
Today or tomorrow, there's no guarantee today. No guarantee.
All right, I didn't hear.
I apologize, this is Jackson from pretrial, there's no guarantee you'll be released today, we have to speak to the owner of the home to see if you can return there. If so, yes today, if not, tomorrow, if not, we will send somebody out physically to verify it. I just can't
Okay, so-
guarantee it.
So what if I can't verify an address? So then what happens?
You go back in front of your judge, your division judge, or your magistrate judge again. You'll be on a
You'll
second
go
look
back.
docket. Second look docket either Tuesday or Wednesday if we can't verify it. You gotta remember, Monday's a holiday.
Okay, thank you.
Okay. All right. Thank you.
Yes. Joseph Spataro.
Conti, Your Honor.
Thank you.
The last one, Stevens?
So we didn't do Sherman.
No, we didn't do Sherman yet.
Okay. So this is Joseph Spataro. Good morning. You're
Good morning.
being held on a KPS misdemeanor, and bond has been set at $5,000 by your judge, and I do find probable cause. Thank you. Okay, Sherry Jean Sherman. Pardon?
Medical reset.
Okay, thank you.
What do you have hiding over there? What's the? Yeah, when you get a chance. I appreciate it.
Kevin Byrne. B-Y-R-N-E. Kevin Byrne.
In jail. Yeah, you had it right. Thank you. Good morning, Your Honor.
Good morning, sir. Sir,
Your Honor, he's representing himself because these are municipal ordinances.
all right. You're being charged with a municipal ordinance violation from Pompano Beach. A municipal ordinance violation from Pompano Beach, and there was a capias from Pompano Beach. Where do you live, sir?
I'm homeless, ma'am. I live under a tree.
And is that your choice? Do you think you have a drug problem or?
No, I have mental problems, ma'am. I suffer from ADHD, bipolar, and I choose not to use the medication because I don't like using drugs. It makes me feel loopy and stuff. All I'm doing is asking for help and getting little odd jobs. I'm not trying to hurt anybody or try to inconvenience anybody, ma'am. I missed my court date because someone gave me some work, and I was going to go down to the clerk of courts and reset it to get another court date, but
Okay, so I am going to release you on your own recognizance, and no bond for one, no bond for two, meaning 0. And for the KPS, it will be $25. Can you do that? And go before Judge Hurley?
So I go to court down there?
Yeah, North Broward.
So I'll be released this morning?
Yes.
Yes, thank you, ma'am.
You're going to be released on all counts.
Okay,
Thank you.
thank you.
I made that.
I hope you have a great Memorial weekend.
Thank you. Freddie Mercado?
No problem, John. Yes, ma'am. Good morning.
Good morning, sir.
Good morning.
You're being charged with an alleged capious misdemeanor.
Your Honor, I have no objection to this. He's, just to make this brief, if I could just get an order for Mr. Mercado to access his cell phone, just so he could get his contact information. He believes he could post bond.
Okay, and it was set at $500. Thank you. Daniel Marico?
Main jail, Your Honor.
Soon as they sit forward.
Good morning. Sir, you're being charged with alleged disorderly intoxication in a public place causing a disturbance. I do find probable cause, and where do you live?
5904 Northwest 27th Avenue.
So you have
Your
a
Honor,
home? Yes.
Yes, ma'am.
the bond was already set at $25. I was wondering if you'd be so inclined to resolve this case today with credit for time served.
Yes, as long as I know what the priors or lack thereof are.
Judge, he was adjudicated on a trespass in 2008, misdemeanor. He has some traffic criminal priors. I'm showing that he has battery on a law enforcement officer and threats to specified individuals, which is a second-degree felony. That's still pending under case number 18003-421 CF10A. One moment, Judge. I see another trespass in 2018 that he was adjudicated on, as well as another disorderly intoxication in 2018. Criminal mischief in 2017.
Okay,
So
thank you.
No problem.
So basically, bond will stay at $25. Thank you.
Thank you, Your Honor.
Rosenberg Sabalas. Good morning.
Your Honor, this is another municipal ordinance. He's representing himself.
You're being charged with a municipal ordinance. And let's see what it is and where. State, does he have any priors?
He has none, Judge.
Okay. So you'll be released on your own recognizance, and the case is still going to go forward. All right?
Your Honor finds PC.
Yes. Okay, Joseph Whiting. Good morning. This is also a misdemeanor capious.
We're right here, main jail.
Yes, I see you. Good morning.
Yes, ma'am.
Your capious was set at $500. I do find probable cause. Thank you.
So what I gotta do?
Dosey Black.
No problem, John.
Good morning.
Good morning, Your Honor.
Okay, so you're being held on a misdemeanor capious set by another judge. I do find probable cause, and the original bond was set at $1,000.
Your Honor, I spoke to Mr. Black this morning, and I also reviewed the probable cause affidavit. I would ask you to consider if you would release him on some sort of non-monetary conditions. He self-surrendered himself to the main jail when he found out he missed the court date. He's lived in South Florida since 2000. He has his mother down here. He has a sister as well. He receives Social Security disability income. He's received that for about the last 3 years. He gets about $900 a month, and that goes towards household bills and his medical expenses. I believe this might wind up being a case where we find out Mr. Black was self-medicating with the cannabis that he was allegedly picked up upon with when the case started. Given the facts, I would ask Your Honor if you would consider some sort of non-monetary release, either ROR or pretrial.
I'll consider pretrial if he can give an address, and just make sure you show up to the court, okay?
Okay, thank you, Your Honor.
Yeah,
It's 16406. Terrell?
1 second, she's writing it down.
I believe it's the address on the face sheet. Sir, it's 16406, and that's going to be in Weston, correct?
Yes, that's
Yeah,
correct.
it's the one on the face sheet.
Thank you.
All right, thank you, Your Honor.
Richard Ischinger, or Ischinger?
Good morning, Your Honor.
Good morning, where are you?
Main jail.
Good morning. So you're being charged.
Good morning.
You're being charged, sir, with alleged resisting an officer without violence. I do find probable cause, and bond is set at $100.
Your Honor, his wallet is in his car, which, he doesn't have possession of, and he lives in a rehabilitation facility requesting pretrial.
That's fine. Just make sure you show up, or you're here.
Yes,
Okay?
ma'am.
All right, thank you. Pretrial. Yeah, ROR to pretrial. Trinidad de Leon. Thank you.
Good morning, Judge.
Good morning, sir. You're being charged with an alleged capious misdemeanor set by another judge at $500, and I do find probable cause.
Your Honor, when it comes to Mr. De Leon, according to the probable cause affidavit in my discussion with him, he was picked up trying to check in at Broward Outreach. He is homeless. He has no income. He's not going to be able to afford any monetary bond. He's a veteran. He has other cases with Judge Merrigan. And what's concerning to me, and Mr. De Leon was confused by as well, is this capious has been pending for quite a few months. He's been in front of Judge Merrigan when this capious was actually outstanding. And so this should have been resolved before. And for some reason, it just got picked up now, even though he's been in front of Judge Merrigan since this capious went out. I don't know if maybe Judge Merrigan didn't catch it because it's misdemeanor, so it's not in front of him, it's in front of a different judge. I'm asking if you would consider an ROR for Mr. De Leon. Any monetary bond, he's going to remain in custody. Again, he was trying to check into Broward Outreach, and that's when this hit.
Okay, so the warrant capious is 0, and will be released on pretrial release. Okay? Thank you.
Thank you.
Jay Shore. Jay Shore,
It should be Maine.
Maine.
He was removed from the docket for confinement status, Your Honor. He's a weekender. No need for magistrate.
Okay.
That's what he just said. He's in Veterans Court.
Robert Jenkins. Sir, you're being charged with alleged DUI, alcohol or drugs, first offense, and DUI with to property of or person of another.
Your Honor, he doesn't have anyone to come bond him out, requesting pretrial.
State.
Your Honor, I'd object to an ROR. This is a DUI with damaged property. He is showing no priors, but I would object to an ROR at this time.
As would,
If, Your Honor, if you wouldn't be inclined to grant pretrial, asking for a more stringent level of pretrial with a bracelet.
with an ankle monitor?
Yes, Your Honor.
I'll do that.
Thank you.
This is
Jenkins.
Robert Jenkins.
Level 2, no bond required one?
No bond, but a GPS monitor. An address has to be verified. Okay. Terrence Mack. Terrence Mack, good morning. Sir, you're being held on a capious alleged misdemeanor on an open container.
I want to resolve it today, ma'am.
Okay, I do find probable cause, and what are some of his, if any, priors?
One moment, Your Honor. Sorry.
Ma'am, I just wanted to say that I just recently started working. I'm working on
Okay, sir,
positive things.
I'm trying to help you, so just wait 1 second, okay?
There's a petty theft in 2018. He was adjudicated on an open container. This is the current charge, I believe. No, he has another pending open container municipal ordinance. 2018 open container, petty theft, withhold. 2017 theft, possession of cocaine. 2013 adjudication, delivery of cocaine and resisting without violence in 2012. Resisting without violence. Oh, I'm sorry, that was dropped. Possession of cannabis in 2012, that was a withhold. Delivery of cocaine and tampering with physical evidence in 2008, that was an adjudication. Sale or delivery of cocaine in 2003, which was an adjudication. Another delivery of cocaine in 2003, that was an adjudication. Loitering and prowling in 2003. Possession of cocaine in 2002. Traffic criminal priors from 2000. And operating without a valid license in 1999.
So,
And a robbery in 1997, excuse me.
all right, so I'm not inclined to resolve the case, sir, at this time. Bond was set by your judge at $250, and it says Division JMH. I'm not sure what that is. Anybody here know?
I'm not sure.
Okay, thank you. Okay, no, don't discuss your case, sir. I rule, thank you. Paul Timmons. Paul,
Medical research, Your Honor. Hey, so I ain't got no
Wilkin Jean-Philippe.
Medical research, Your Honor.
Thank you, sir. Ivan Ferguson. Good morning. Sir, you're being charged with good morning, with 2 counts of allegedly resisting an officer without violence, driving while license suspended, first offense, and a traffic ticket. Do you have a probable cause argument? Okay. So, there is, I do find probable cause. Does he have any priors?
Possession of cannabis in 2015, Judge.
And that's it?
That's it.
Okay, so I'll dismiss count 4, because it's a traffic ticket, and I'm going to ROR and put him on pretrial release, pending address verification. Thank you. Juan Mans.
Paul Ryan, Your Honor.
Good morning.
Good morning.
Sir, you're being charged with counts 2, 3, and 4 lewd or lascivious conduct by a person 18 years or older on a victim less 12 years and under 18, and by a person 18 years or older. What is the state's recommendation?
Your Honor, the state's recommendation is on count 2, at least a $50,000 bond. On count 4, at least a $50,000 bond, and for Your Honor to find proof evident presumption great for count 3.
Okay, so bond on count 2 is $50,000. Bond on count 3, I do find probable cause. I further find proof evident or presumption great. Therefore, you are to be held without bond until further order of the court, and this order is without prejudice, so the defendant can file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. Thank you, and number 4 is $50,000 as well.
Your Honor, when it comes to count 3, I'm objecting to the finding of proof evident presumption grade. Again, I'm going to cite to the case Usaza v. State, 222 Southern 3rd, 3. Reading the probable cause affidavit, because we do have for the different cases in front of us, but for this particular charge, what concerns me is that there's no sworn testimony, and beyond that, there is no clear indication or any indication whatsoever how identification was made. There is no mention of any photos being shown to the alleged victim. There's no lineup that's ever mentioned. I have no idea how any identification was made to identify or make any allegations that they're coming forward with here with that victim. Again, the 4th DCA is clear that proof evident presumption grade actually goes beyond a reasonable doubt. I do not think the state would be able to win a trial today given this lack of information, given the lack of any sworn testimony, any live testimony, or any indication of how identification was made. Because of that, I would object to the finding of proof evident presumption grade, which goes beyond a reasonable doubt, ask Your Honor to set monetary bond, and even if Your Honor is inclined to find proof evident presumption great, it is within Your Honor's discretion to set a monetary bond. Count 1 in this case, I believe, is the same count, or excuse me, it's the same charge as count 3, and that bond was set at $100,000.
So over your objection, everything is staying the same. Andrew Brian Spence. Good morning. Sir, you're being held no bond on 2 alleged felony violations of probation, and the court does find probable cause. You are going to see your judge on June 5th at 9 a.m. Thank you. Robert Ibarra. Good morning. Sir, you're being charged with 1 count of burglary of an unoccupied conveyance, unarmed, possessing burglary tools with intent to use, and resisting without violence. I do find probable cause for all 3, and we need to set a bond for count 1.
Your Honor, defendant has no priors. I'd be recommending a bond of $5,000.
And Your Honor, he is 19 years old. He's a student at Broward College. He lives with his parents. This is his first offense. We're requesting pretrial.
Okay, I'm going to do pretrial and make sure you follow the rules and recommendations and keep going to school. Thank you.
And Your Honor, is it pretrial for all counts? Because he does have bond set for possession of burglary tools and resist without violence.
Yeah.
Okay, thank you. And a photo, I guess he'll be released, so never mind. We don't need a photo order. He'll be out. Thank you.
Jacoby Hobbs. Good morning.
Good morning, Your Honor.
Sir, you're being charged with 1 count possession of cocaine, a $1,000 bond, a 2nd trespass for failing to leave property by the owner, and probation violation of a felony. So I do find probable cause on all 3, and your next hearing is May 31st at 8:30 a.m. Thank you. Brandon Holloway. Brandon Holloway?
That's a medical reset, Your Honor.
Okay, thank you. Jose Cruz. Good morning. Sir, you're being charged with alleged felony violation of probation for which there's a no bond hold and a second writ of arrest, which is set at $420. And I do find probable cause. Your next court hearing is June 1st, 8:45 in the morning. Thank you. Carnell Golden. Good morning. Sir,
In Your Honor, I'll ask for you to waive a formal reading. I'll just have my colleague explain the charges to him.
okay, and what is the state recommending?
Your Honor, the state would be recommending a $100,000 bond for count one.
And Your Honor, this is his first offense. The most he can pay is $1,000. He's lived in Miami his whole life, and he works for waste management.
He has a use of possession drug paraphernalia in 2013, which was an adjudication, and traffic criminal priors, and that's all I'm showing.
All right, bond is $100,000 over the defense's objection. Thank you. Alfonso?
And Your Honor, I'm sorry, just invoking his right to remain silent on the record.
Okay, thank you.
And Your Honor finds PC.
Yeah. Alfonso Campos. Alfonso Campos, good morning. So you're here on 2 alleged violations of felony probation for which no bond on each. And your next hearing is June 5th at 8:30 a.m. Okay, thank you. Don't talk to anyone but your lawyer. Antoine Moore. Good morning.
Morning, Your Honor. Main jail.
Anyone have any probable cause objections? Okay, so I do find probable cause on possession of a weapon by a convicted felon for which we need to set bond. What is the state recommending?
State recommendation, Judge, is $7,000 for count one.
So it's gonna be $7,000 for count one. You have 2 alleged possession with intent to sell or deliver cocaine and cannabis, both set at $1,000. Possession of cannabis over 3 grams, $1,000, and drug paraphernalia, $100. Tampering or fabricating with physical evidence, $1,000. And I do find probable cause. Thank you.
Your Honor, he has lived in Broward his whole life. All of his family's here. He has a child, and the most he can afford is $600 to $800 in bond.
He'll speak to his division judge. Okay, thank you.
Thank you, Your Honor.
Criminal, look, Paul Mahwini. Mahwini? M-A-W.
He's on medical loan, Your Honor.
Oh, thank you. Joel Bailey. Good morning, sir. You're being charged with 1 case of alleged aggravated assault with a deadly weapon without intent to kill, child neglect without great bodily harm, and disorderly conduct. Bond on count 3 is $25. I do find probable cause on counts 1 and 2, and we need to set a bond.
Your Honor, he's lived here for 7 years, his parents, and he has 2 daughters here. He works as a security guard.
Your Honor, I'd be asking for at least a $10,000 bond on count 1. For count 2, at least a $5,000 bond, and if he makes that, to be released to pre-trial with a DCF investigation.
So ordered. 10,000 on one, 5,000 on two, $25 on three. If post bond, you will go to pretrial and there'll be a DCF review, right? Okay, thank you. Shavane Merritt. Sir, you're being charged on a total of 9 charges. 1, 2, 6 of which are obtaining property over $20,000 by fraud. And, I'm sorry, obtaining property over $20,000 by fraud. That's one charge, but it's your 9th charge. That's bond is set at $10,000. And 3 grand thefts for which bond is set at $1,000 each. And then obtaining property by false impersonation, 1, 2, 3, 4, 5, and those are all $1,000 each, and I find probable cause. Thank you.
Your Honor, this is his first offense. He's lived here for 2 years. His grandma and his aunt live here. He's a supervisor at BrandSmart. Defense is requesting pretrial. He can't afford this bond. The most he can afford is like $500.
State, any particular objections if I do that?
It's the fact, Judge, that this has been an ongoing scheme on behalf of the defendant that took place over months. And as far as the amount of charges, I would be objecting to an ROR to pretrial.
Okay. So I'm going to keep things as they are. Good luck to you. Thank you. Travis Moultrie.
He bonded out, Your Honor.
Thank you. And Ralph Proenza.
He also bonded out, Your Honor.
Thank you. Find probable cause on both of those. Okay. Robert Daly.
No problem, Your Honor.
Good morning, sir.
Good morning.
You're being charged with alleged DUI, alcohol or drugs, first offense, and driving while license suspended with knowledge, third or subsequent offense.
Your Honor, when it comes to Mr. Bailey, I have no objection. The only thing I'm asking for is if he could access his cell phone. He believes he could post bond. He just needs the phone numbers off the cell phone.
Okay. So, yes, access, cell phone, in car, is that where it is?
And property with him. So BSO will just monitor.
Thank you.
Thank you.
And bond on count 1 is $500, and bond on count 2 is $750, and I do find probable cause. Thank you. Andrew Chin. Good morning. Where is Mr. Chin?
Maine.
Thank you. Okay, Mr. Chin, it looks like you have visitors. First, I'm going to read the charges. The first one is aggravated assault with a deadly weapon without intent to kill, touch or strike battery, and disorderly conduct. And I do find probable cause. And who are these visitors before me?
His mother and father.
Okay, your mom and dad are here. Are you going to let's hear what the state is recommending, and then if you wish to talk or tell me what you think.
Your Honor, based on the fact that there was a firearm involved, the defendant is showing only traffic criminal priors. Based on the fact that a firearm was used, to be asking for at least a $10,000 bond on count 1, and for bonds of $1,000 on count 2 and $25 on count 3.
Okay, before I make my decision, you want to tell me anything?
Andrew is gainfully employed. He just signed back up for school.
Please raise
Show
your
him
right
sorry.
hand. Do you swear and or affirm the testimony you give will be the truth and nothing but the truth?
Yes, ma'am. Yes.
Please state your name for the record.
Andrew Chin.
Mia Carla Beck.
Okay, and what do you want to tell me?
Andrew is gainfully employed. He's never been in trouble with the law. He just signed up back for school, and the most that we can afford to bond him out is $500.
And Your Honor, for the record, Mr. Chin did not have the firearm. He's lived in Broward for 20 years. He works at Hemisphere Hotel, and he lives with his mother and father.
Your Honor, if you pay attention to the probable cause affidavit, it is stated by the officer that Chin stood with the firearm, charged it and pointed it in a threatening manner, and then began to strike the victim with it in the area of his head and face. And also, Your Honor, if he does make bond, it asks for pre-trial with no victim contact. Excuse me.
It'll be pre-trial release with no victim contact. And bond is set at $500 for all three.
I appreciate it.
Like, altogether,
Altogether,
500.
I appreciate it.
And you want him home, right?
$250
Yes.
on count one, then.
Okay.
Thank you, Your Honor.
It's gonna be 2 on count 1, 100 on 2, and 100 on 3.
Right. Right. No,
That's 400.
so,
Let's do 200 on 2. 200 on 1, 200 on 2, and 100.
okay.
Pre-trial, no victim contact, Judge, is that?
And no victim
Okay.
contact.
Yeah, I hope the victim,
And
the
pre-trial-
person doesn't contact him
pre-trial-
also.
Excuse me.
And
Yes, I'm
pre-trial,
sorry.
and you're lucky as parents to
Thank
love
you.
him.
Pay the bond.
And Your Honor, is that standard pre-trial? I'm sorry.
Yes.
Is that
Standard.
standard? Thank you.
Please make sure he reports Tuesday before 2 o'clock, before noon, okay, on Tuesday.
Okay.
He'll get a map before he walks out the door. Okay, appreciate it.
Edilberto Castro Galeas. Good morning.
Your Honor, I'll waive formal reading of the charges. I'll just have my colleague explain them.
Okay. I do find probable cause, and what is the state recommending, and who are you?
My name is Debbie Levy. I'm a detective with the Hollywood Police Department, lead investigator.
And Your Honor, at this time, the state would be requesting that Your Honor find proof evident presumption great for counts 1 and 2.
I find proof evident, first of all, I find probable cause. Second of all, I find proof evident presumption great. And I further find proof of guilt to be evident or the presumption to be great. Therefore, you are to be held without bond until further order of this court. And of course, if you wish, you can file a defense motion to set bond under State versus Arthur. Thank you. Christopher Vasquez.
He bonded out, Your Honor.
Thank you. Antonio Davis.
Medical research, Your Honor.
Thank you.
Come on, Russ.
Andra Rett.
Medical reset.
Sorry. All right. Eric Russell.
North Broward, Your Honor.
Thank you. Good morning.
Good morning, ma'am.
Sir, you're being charged with one count of robbery by sudden snatching with a firearm or weapon, and a second violation of parole for which there is a no bond hold, and I find probable cause for both charges. What is the state recommending on count 1?
Your Honor, on count 1, the state would be recommending at least a $13,000 bond.
On count 1, bond is set at $15,000. Thank you, and the no bond hold on the parole.
15,000, how much is that?
Sir?
With the 10%, how much is 15,000?
And you have a no bond hold for a felony.
For the parole.
Parole.
Right.
It's only 26 days, ma'am, on parole.
Okay, I can't do anything about it, but your judge will have to. The judge who you see, you'll speak to. Okay? Thank you.
All right.
Gabriel Carrasco.
Medical research, Your Honor. How much is that?
Chad Lowe. Chad Lowe. There's no Chad Lowe anywhere?
be on medical loan. I guess he's in the hospital.
Okay, a medical reset. Thank you. And Trevor Paquette. Trevor Paquette.
Your Honor.
Pardon?
Main jail.
Okay, good morning. Sir, you're being charged with a second charge of kidnap or commit or facilitate commission of a felony for which bond needs to be set. I do find probable cause. Say it.
Just one moment, I'm just looking to see what the original bond amount was. I believe this is a punishable by life felony. Just double checking, Judge, that I would ask you to find proof evident presumption great that it's a punishable by life felony.
Okay, so, Mr. Paquette, I have reviewed probable cause on count 2. I find probable cause. I have reviewed the affidavit, excuse me. I find further proof evident of guilt or the presumption great. Therefore, you are to be held without bond until further order of the court, and you may file a motion under State versus Arthur to set a monetary bond. Thank you. Okay, Franklin Whitehead.
Conti, Your Honor.
Good morning.
Good morning.
Sir, you're being held on count 6, felony capias, count 7, felony capias, and count 8, felony capias, all of which have been set by your judge at $1,025 and $25. And I do find probable cause. Thank you.
Your Honor.
Don't
Your
talk
Honor.
about it, don't talk, I can't change another judge's bond. So,
No, I want to.
altogether, it's going to be $1,050.
I want to know. Ask, can I get it resolved today?
You can't resolve felonies today, sir. You have to resolve it in front of your division judge.
George Prince. Good morning. Sir, you're being charged with tampering or with physical evidence and resisting an officer without violence. I do find probable cause, and what is the state's recommendation?
Your Honor, for count 1, the state's recommendation is $1,000.
And Your Honor, he can't afford that. He lives with his mother. He's a lifetime resident of Broward County.
Does he have any priors?
One moment, Judge, sorry. It's frozen.
And he does receive disability insurance payments, Your Honor.
Judge, he does have alcohol beverage violation, which was a withhold municipal ordinance, adjudication on a trespass in 2013, another alcohol violation in 2013 municipal ordinance. I'm showing some misdemeanors, trespass in 2013, 2 of them, which were withholds, more municipal ordinance violations, 2012 for the same offense, trespass in 2012, another
Okay.
trespass.
All right, so what did you say? What are you recommending?
Your Honor, in light of his history, I'm requesting a pretrial with a bar eval.
So ordered. Thank you.
Thank you, Your Honor.
That's it. I'm done.
with parking.
This was quite a work